Picture this. You're driving home after a long day. Maybe it's late. You're tired. Your only goal is to get through the front door and rest. Then suddenly, red and blue lights appear in your rearview mirror. Your stomach tightens. You pull over. Your hands begin to shake a little. You expect a routine traffic stop. But when the officer walks up, something feels off. The uniform patch isn't from local police. The badge doesn't say Highway Patrol. It's a federal badge. It's ICE. In that moment, with your heart racing and thoughts scattered, most people make choices that create serious problems for them. Not because they're dangerous, and not because they've committed a crime, but because they talk too much, argue, move suddenly, or say things that later cannot be taken back. Here's the uncomfortable reality. The first minute of that encounter often shapes everything that follows. Agents know that people are nervous. They know most drivers are confused about their rights. They know many people will try to explain their way out of a stressful situation, and that's exactly when critical mistakes get made. The good news is this: there are a handful of short, clear sentences that can dramatically change how that encounter develops. If you don't know them and don't use them quickly, you may not get another chance to protect yourself later. There are also several very common traps in this type of stop. Not tricks in a fictional sense, but predictable pressure points that lead many people to cooperate in ways that hurt them legally. Even thoughtful, educated people who believe they understand their rights still fall into them. So before you ever find yourself on the shoulder of a road with federal agents at your window, it's important to understand what's actually happening in that interaction, how stress affects your decision-making, and how to respond in a way that protects you instead of harming you. Hi, I'm Timothy, and on US Updates Hub, we break down real-world legal encounters so you know how to navigate them before you're ever in that position. The goal here is not to make you afraid, it's to help you be prepared. Because when you're prepared, a tense situation is less likely to turn into a life-disrupting one. This isn't about politics or policy debates. It's about psychology, constitutional protections, and how quickly casual conversation during a stop can turn into evidence in a file. When people are stressed, a very human instinct kicks in. They start defending themselves verbally. They over-explain. They try to prove they're good. Unfortunately, that instinct is exactly what often creates complications in immigration and criminal cases. In this video, we'll walk through the most common escalation patterns in these stops, how agents use tone and questions to gather information, how consent to a search can remove important legal defenses, and why simply staying quiet is not always enough on its own. You'll learn specific, simple phrases you can actually remember when your heart is pounding and your palms are sweaty. Because here's what most people underestimate. Once those lights flash behind you, your body goes into a stress response. Your brain stops thinking about long-term consequences and focuses on ending the discomfort right now. That's when you start talking. That's when you answer questions you're not required to answer. That's when you try to correct or challenge the officer, and agents understand that dynamic very well. They know silence feels uncomfortable. They know uniforms carry authority. They know many people were raised to believe that when an officer asks a question, the right thing to do is answer it. But a roadside stop is not a classroom. It's not a friendly chat. It is a legal encounter. Every word, every nod, every movement can later be described, written down, or played back. And the difference between a brief stop and a serious legal problem can come down to one or two sentences spoken while you're under stress. So let's set a baseline principle before we go any further. You do not resolve legal issues on the side of the road. You don't win your case there. You don't prove your innocence there. You don't correct errors in the system there. Those things happen later, in more controlled environments, with time to think and with proper representation. The purpose of the roadside encounter, from your perspective, is to stay safe and protect your rights, not to argue your case. With that in mind, let's look at the most common mistakes and what to do instead. The first mistake almost everyone is tempted to make is immediate confrontation. The window rolls down, the badge appears, and the words fly out. Why did you stop me? You can't do this. This is illegal. This is profiling. It can feel empowering in the moment, like you're standing up for yourself. But the side of the highway is not where legal arguments are settled. Once the interaction becomes confrontational, the emotional temperature rises quickly. When that happens, many officers mentally shift into what could be called control and safety mode. From that point on, they interpret everything through a different lens. Your frustration can be interpreted as agitation. Your raised voice can be described as non-compliance. Your sharp tone can be documented as hostile. Whether that description feels fair to you or not, the fact is that perception often drives reaction in the moment, and that is not to your advantage. So instead of trying to litigate the legality of the stop out loud, you focus on what is within your control. Keep your hands visible. Move slowly and predictably. Speak calmly and briefly. If you're the driver, in most places you are required to provide your driver's license and registration during a lawful traffic stop. Complying with that requirement is not giving up. It's meeting a basic legal obligation. If you're a passenger, the rules may be different. In many situations, passengers are not required to show ID or answer questions about themselves. However, it's also important to know that during a traffic stop, courts often consider passengers detained along with the driver. That means simply opening the door and walking away because you're frustrated can escalate things quickly. So instead of arguing, lecturing, or trying to win on the roadside, you use one calm sentence. Officer, I will follow lawful instructions, but I'm not going to answer questions. No attitude, no sarcasm, just steady, neutral words. You are not admitting anything. You are not waiving your rights. You're signaling that you understand the distinction between required physical compliance and voluntary verbal cooperation. That shift alone prevents many early escalations. The second major trap is what feels like harmless small talk. The tone is light. The questions sound casual. Where are you headed tonight? Where are you coming from? Who's the car registered to? Is there anything in the vehicle I should know about? Where were you born? When the tone is polite, most people default to being polite in return. We're conditioned to fill silence, especially with authority figures. Not answering feels rude. So we explain. We overshare. We answer questions that were never actually required. Under stress, this gets worse. Adrenaline affects memory and sequencing. You may give times, distances, or details that aren't perfectly accurate. Later, those minor discrepancies can be used to question your credibility. A casual mention about where you were born or who you live with can be interpreted in ways you didn't anticipate, especially in an immigration context. It's also important to understand that questions aren't only about the content of your answer. Officers are trained to observe how you answer, your tone, your hesitation, your eye contact, your breathing, your body language. The longer you talk, the more there is to analyze and interpret later. And once a statement is made, it cannot be unsaid. So instead of engaging in an extended back and forth, you use a simple, repeatable phrase, I'm exercising my right to remain silent, or I plead the fifth. You don't need to deliver a speech. You don't need to recite case law. A clear, short statement is enough to invoke your right to remain silent. If questioning continues, you repeat it in the same calm tone, I plead the fifth. I'm choosing not to answer questions. You may hear things like, so you're refusing to cooperate? Only people who have something to hide stay silent. Recognize this for what it is, pressure, not law. There is no rule that says innocent people always talk. Many people remain silent precisely because they understand the stakes. Cooperation does not mean providing information. You can cooperate with physical instructions while still declining to answer investigative questions. That distinction is important. Awkwardness fades. Words on a report do not. The goal is not to impress the officer. It's to avoid creating statements that may be misunderstood or misused later. The third trap that quietly removes a lot of legal protection is consent to a search. Requests often sound casual. You're okay with me taking a quick look inside, right? Mind if I just check the back seat? If there's nothing to hide, this won't take long. The phrasing is social, not legal. It's designed to make no feel uncomfortable. Many people say, sure, or I guess, simply because they don't want to seem difficult. Others mumble something that can later be interpreted as agreement. From a legal perspective, though, your answer here matters enormously. If you clearly consent, it can become much harder later for an attorney to challenge that search in court. Arguments about lack of probable cause or reasonable suspicion often do not apply in the same way when a person gave permission. So you don't answer with, yeah, I guess, or it's fine. You don't debate how long the search will take. You use one clear sentence. I do not consent to any searches. That's it. No qualifiers, no extra explanation. Then you follow up with, am I free to leave? That question serves two purposes. First, it makes your lack of consent unmistakable. Second, It pushes the officer to clarify whether the legal basis for the original stop is complete or whether there is some additional reason for continued detention. If they say you are free to go, you leave calmly. If they say no, you've at least established a clear point in time when the stop moved beyond its initial purpose, which can matter later in court. And even if you are absolutely certain there is nothing unlawful in your car, there are still reasons not to invite a search. Cars can be taken apart, property can be disturbed, stress and confusion can increase. A search is not a neutral experience. Refusing consent does not mean you're hiding something. It means you understand that your privacy has value and that any search should meet proper legal standards rather than rely on your social discomfort. The fourth trap has nothing to do with words and everything to do with movement. From your perspective inside the car, reaching for something quickly might feel natural. From an officer's point of view outside the vehicle, sudden or unexplained movement can be frightening. Officers are trained to watch for quick leaning, reaching under seats, digging into bags or pockets, turning or twisting suddenly out of view. Once an officer believes they had reason to fear for their safety, courts often give that perception significant weight. So you treat your movements as deliberately as you treat your words. Keep your hands in view, on the steering wheel if you're driving. If you need to reach for something, say so first. My registration is in the glove box. I'm going to reach for it slowly. Then move slowly, with no sudden motions. If there is something sensitive in that area, such as a lawfully possessed firearm, it is especially important to communicate clearly before moving. Officer, the documents you requested are in the glove box, and there is a licensed firearm in there as well. How would you like me to proceed? One very clear safety rule: do not reach for a weapon during a stop. Even if you believe you are legally allowed to possess it, even if you're trying to show that you're being transparent, letting officers control any contact with a weapon significantly reduces the risk of misunderstandings. If you are ordered out of the vehicle, comply. Courts have held that officers may order drivers and passengers out during lawful stops for safety reasons. Arguing about that order on the roadside rarely helps and often escalates matters. Likewise, if you are a passenger, do not simply walk away during an active traffic stop. Even if you feel you've done nothing wrong, leaving can be seen as refusal to comply and can lead to physical restraint or arrest. Your aim is to keep the encounter as calm and predictable as possible. Follow physical instructions, avoid sudden movements, keep your hands visible. The calmer your body language, the narrower the justification for escalation. Finally, there's a trap that surprises many people. Assuming that staying completely silent, without saying anything at all, automatically protects you. Silence is better than over-explaining, but in many legal contexts, courts have said that you must clearly state that you are invoking your right to remain silent. In other words, silence plus clarity is stronger than silence alone. If you simply sit quietly without saying anything, officers may continue questioning. Some courts have even allowed silence to be interpreted in ways you might not expect, depending on the situation. That's why it is important to say something like, "I'm exercising my right to remain silent," or "I plead the fifth." Those words put everyone on clear notice. If body cameras are recording, those recordings will capture your invocation. That record can become very important later. And if the situation escalates, if you are told you are being detained beyond a temporary stop or placed under arrest, one more sentence becomes critical. "I want a lawyer." Not, "Maybe I should talk to an attorney." Not, "Do I need a lawyer?" A direct, unambiguous statement. "I want a lawyer." After that, you should stop answering questions. So, to summarize the key protective phrases, I'm exercising my right to remain silent. I plead the fifth. I do not consent to any searches. Am I free to leave? I want a lawyer. They are short enough to recall under stress and clear enough to stand up to later scrutiny. Let's quickly walk through a sample encounter to make this more concrete. You pull over, engine off, hands on the wheel. An agent approaches. You roll the window down partway. "Where are you coming from tonight?" "I'm exercising my right to remain silent." "Why won't you answer my question?" "I plead the fifth." "Is this your car?" "I'm choosing not to answer questions." They look irritated. "So you're refusing to cooperate?" "I will follow lawful instructions, but I'm not answering questions." They shift. "You don't mind if we take a quick look inside, right?" "I do not consent to any searches. Am I free to leave?" From there, they may decide to let you go, or they may continue the encounter, but you have avoided arguing, avoided volunteering personal or immigration information. Clearly refused consent to a search limited the amount of material that can be documented and analyzed. If at some point you are told you are being taken into custody, you say, I want a lawyer. And then you stop answering questions entirely. That may not feel emotionally satisfying in the moment. You may want to explain, you may want to defend, but strategy requires discipline. Being precise protects you more than being persuasive. To close, here's the key idea. Stress changes behavior. Flashing lights, uniforms, and authority can push anyone into saying and doing things they later regret. You cannot rely on, "I'll figure it out in the moment," when your nervous system is in overdrive. Preparation changes that. If you've heard these phrases before, if you've pictured yourself using them, it becomes easier to access them when it matters. So rehearse them. I plead the fifth. I'm exercising my right to remain silent. I do not consent to any searches. Am I free to leave? I want a lawyer. This video is for general educational purposes only. It is not legal advice. Laws and procedures can vary by location and by case. If you have questions about your specific situation, speak with a qualified attorney who can advise you based on the facts of your case. Remember, your goal during a roadside encounter is not to win an argument. It's to stay safe and avoid creating additional problems for yourself. Calm, clear, limited speech, and controlled actions do more to protect you than any speech delivered under stress. Stay informed, stay prepared, and if you found this helpful, consider sharing it with someone who might benefit from hearing it before they ever need it.